Hello everyone, I welcome you back to our channel. This is Legal Mindset at the bar. So I urge you to subscribe, share, like and comment where you feel like you're not satisfied. And in today's session, we are going direct to look at the topic of consideration, one of the core topics of contract law 1. We are in contract formation and we are going to look at the topic of consideration as one of the elements of a valid contract. What should you expect from this video? You should be able to know what consideration is by the end of this session, the types of consideration, the rules governing consideration. So I urge you to keep on until the end of this video, where I shall give you a number of interesting cases that portray what amounts to consideration. We are in a period of exams at a number of universities, IUIU, Kampala International University, Kumba University. I dedicate this video to you. I urge you students to tap the subscription button below, turn on the notifications, because in this period of exams, we are going to release a number of topics, a number of core topics, a number of examinable topics. And we shall also give you a video on how to answer contract law 1, how to answer a number of course units. So turn on the notifications and subscribe such that new videos are brought to your attention. Now, what is consideration? Consideration is a promise of something of value given by a promiser in exchange for something of value given by a promisee. Quote my words very well. Consideration is the promise of something of value. What is that something of value? It is the consideration given by a promiser. Who is a promiser? The person who proposes the terms of the offer in exchange for something of value given by a promisee. The promisee is the person who gives their something of value such that they get the consideration of the other party by also giving in their consideration. I urge you to look at section 1, which shall define for you the legal definition of consideration. Now, as a layman, let us define consideration by a clear example. Like when I want to sell my car to Counsel Joshua. My car is the something of value, and in this contract, I'm the promiser. So it means Counsel Joshua is the promisee, and the money he will give me shall be his consideration, shall be his something of value, as you add in the definition. If you go and you look at section 19, subsection 1 of the Contract Act, cap 284, it states that an agreement made without consideration is void. Now, what are the types of consideration? I'm going to give you two types of consideration. Now, we shall look at executed consideration, executory consideration. And in executed consideration is where a party performs an act they have promised in exchange for a promise by the other party. This is the daily day consideration. You go to the shop, you give their money, they give you soap, they give you sugar, they give you honor. That is the executed consideration. Give me, I give you. You can also look at executory consideration, the exchange of a promise where a party promises to perform a specific act in the future in return to perform another act. You get? Here, it is different from executed consideration. Here, you get your promise to be given something, but it is not give me, I give you. You can do and you are expecting in future. That is executory consideration. What are the rules governing consideration? This is the gist of our video. I urge you to subscribe, share, like with your colleagues. Have a good heart. Share with your colleagues. We are going in the period of exams. Share with them this video of consideration because it is sacrosanct and paramount, and it is very crucial for your passing, because I don't think a paper can come without the topic of consideration. It is technical. Now, let us dive into the rules of consideration. We shall start with the rule that states consideration must move from the promisee. What do you understand when you hear that consideration must move from the promisee? If you go to section 1 of the Contract Act, it shall define for you who is a promisee, who is a promiser, and what is a promise. A promise to mean an offer which is accepted. The promiser to mean the person who makes the offer. The promisee means the person who accepts the offer. Now, any person who wishes to enforce a contract must show court that they provided consideration for it. Here is another way of saying it. The promiser must show court that the consideration moved from them. The promisee must show court that yes, the consideration moved from me. I have the obligation under the contract, because the law of contract does not entertain outsiders or strangers to the contract. It only deals with the parties to the contract. The rule that consideration must move from the promisee creates the doctrine of privity. A party who is not part of the contract cannot enforce it. I'm now going to take you through a number of interesting cases to elaborate more on the rule that consideration must move from the promisee. And take this break to subscribe and share with your colleagues. So, I'm going to give you the case of Tweedo versus Atkinson. I also give you the case of Dunlop versus Selfridge. Now, in Tweedo versus Atkinson, a case of 1861, Queen's Bench, page 167, a couple were getting married. The father of the bride entered into an agreement with the father of the groom that they should give a certain amount of money to their children upon their marriage. The marriage took place, but both parents died before making their promise, before making good their promise. Now, the groom went on to sue the executors of the will of the father so as to recover the money the father had promised. Court held that the groom was not party to the contract and he could not participate in it, in its enforcement. Why? No consideration moved from her. She was not the promisee in the contract. Let us now look at another case of Dunlop Tire Company Limited versus Selfridge and Company Limited, a case of 1915 SC, page 847. And in that case, Dunlop and Company sold the tires to Dew and Company, but they agreed with Dew and Company never to sell the tires below a specific amount of money. Now, Dew and Company also went on to sell the tires to Selfridge, but he remembered Selfridge of the rule that do not sell the tires below a specific amount of money. Selfridge now, a money-minded man, a good businessman, sold the tires below the specific amount of money they had agreed upon with Dew and Company. So, Dunlop now came in to to sue Selfridge and company for breach of contract, and he sought for damages. Now court held that Dunlop would not sue in that contract because no consideration moved from them to Selfridge. The contract was in between Dew and company and Selfridge, and not Dunlop and Selfridge. The House of Lords held that Dunlop could not sue Selfridge because there was no consideration moving from Dunlop to Selfridge, and that the party who is not part of the contract cannot enforce it. If you go and look at the holding of Lord Holden, who stated that only a party who is part of the contract can enforce it. Now, let us look at another rule of consideration, which states that consideration must be legal with a lawful object. What does this mean? This means that consideration must not be prohibited by law or against public policy. Take an example, like I enter into a contract with my friend Council Joshua to buy his goods, but we all know that he smuggled the goods. Now, the object of consideration is prohibited by law. It was achieved by smuggling. Even though I do not pay him, he cannot enforce that contract. An example, a clear one, you hire someone to kill for you someone. After killing the person, they come and they tell you, you pay me, I finish the job, and you refuse to pay. If you refuse to pay, that party cannot enforce that contract. Why? The object of consideration is prohibited by law and it is against public policy. I urge you to look at the case of Foster versus Driscoll. In Foster versus Driscoll, a contract was entered into for the buying of a whiskey and selling it in the USA, which at the time in the USA there was a law against alcohol. That law was commonly known as the time of prohibition. So during that time of prohibition, Foster and Driscoll, for them, they went on to conclude a contract for shipment of the prohibited alcohol. Now, the defendant refused to pay the plaintiff. The plaintiff went to court to enforce the contract. Court held that the contract was unenforceable because its object of consideration was illegal under the law of USA. Let us now continue to another rule, that consideration must be sufficient but need not be adequate. What does this mean? Consideration must be sufficient but need not be adequate. It means that for as long as there is something of value, the courts will not come in to investigate its adequacy. Take an example, like I have come here and purchased a glass of sparkling water. $5,000. But when I go to another hotel and I find out that this water is $2,000, I cannot enforce it. Why? They gave me something of value and I gave there something of value. Courts will not come in to say, well, both parties are equal. Did they get equality in their contract? No. For as long as you exchange something of value, consideration must be sufficient but need not be adequate. I urge you to look at the case of Thomas versus Thomas. In Thomas versus Thomas, the plaintiff, whose deceased husband, had decreed that upon his death, she could pay £1 for the matrimonial house and live in it. So, the executors of the will of the man now saw this as fraud. They went on to court to say that it was not adequate for the woman to stay in the house for only £1. But court went on to hold that for as long as the woman paid the £1, it was sufficient. As long as she paid the £1 annually each year, it was sufficient and the consideration was sufficient and it does not need to be adequate, and the contract was enforceable. Let us now look at another type of consideration, another rule of consideration. We are going to look at a technical rule. Consideration must not be passed. Here, I urge you to pay attention. And if you have any colleague who is your friend, share them this video. Because indeed, it is well revised and it is clear to the point. Consideration must not be passed. This means that any act done before a promise is made cannot be used as consideration for the promise. Take an example like I live near my friend Council Joshua. Our houses are close. Now, when Council Joshua goes to the village, say for example, and a tree falls on his house, then I remove without contacting him. I remove the tree. I sweep. I bring plumbers. They repair everything. I bring new iron sheets. And when Council Joshua comes back, I tell him that Council, the tree fell down on your tree or on your house, but you pay me. Then he says, I'm going to pay you $1,000. Now, if he reaches time and he refuses to pay, I cannot successfully sue him. My claim will fail. Why? Consideration must not be passed. If you've done a thing in the past, you cannot enforce it in the future. Take an example like, let us go straight forward to the case of Rimakedo, a case of 1951, which elaborates it well. In this case, Mrs. Marjorie Rimakedo made improvements and repairs on a house. After repairment, the owner came back and the owner pledged to pay her £480, but later the owner refused to pay. Now, Mrs. Marjorie Rimakedo sued for breach of contract. Court held that consideration was passed in that contract because the work was done before the consideration was made, and that the contract was not enforceable, and that the other party was not bound to pay Mrs. Marjorie Rimakedo. Now, let us go to another rule, that performance of an existing duty is not sufficient consideration. So the rule is that performance of an existing duty is not sufficient consideration. It means that if someone is under a public duty to do a particular task, then agreeing to do the task for a certain sum of money is not sufficient consideration. Take an example like an askari of a primary school who enters a contract with a mother of a child at that school for the askari to provide protection to that child. That is not sufficient consideration. Why? The school has already hired that askari to take care of to take protection of all children. Now, look at the case of Collins versus Godfrey. And in Collins versus Godfrey, Collins had been legally required to attend the court as a witness for Godfrey. Godfrey promised to pay Collins for attending court and giving evidence. Collins attended court but was not called to give evidence. He later sued Godfrey to recover the payment. Court held that since Collins had a legal duty to attend the court, he provided no consideration to Godfrey's promise, and the contract was not enforceable. That is the rule, that performance of an existing duty is not sufficient consideration. You can look at the rule that part payment of a debt is not valid consideration for a promise to forego the balance. The general rule here is that when someone owes you a sum of money, if you pay part payment of that sum of money, that little sum of money cannot satisfy the larger sum of money. This rule was propounded in the common law case of Pino's case, where Cole owed Pino £8, but Cole and Pino agreed that Pino should be paid £5 to satisfy the full payment. But later, Pino went from the agreement and sued Cole for the remaining balance. So, court ruled in favor of Pino and said that part payment of a debt is not valid consideration for a promise to forego the balance. Those are the rules of consideration. Thank you for watching, sharing, liking, and commenting. And if you watch, just like, just share with your colleagues such that they also watch in this period of exams to enable them score high as you're going to do. I urge you to hit that subscription bar below and turn on the notifications, because we are releasing more videos in this period of exams to help you and enable you pass high in your exams. Thank you very much.